Welcome to the 68th session of Legal Empowerment Through Interaction lecture series. The wonderful journey of empowerment and realization continues. Today, a subject which we have not touched during the last sessions, any of the sessions, we are going to step into that, taxation. A primary duty of every citizen is to pay taxes, and nowadays we claim that we are being overtaxed. Anyway, let us hear it from the wonderful speaker, Adv.Karthik Sundaram. He is from Madras, and thank you, Advocate P.T. Mohan Kumar, for introducing this wonderful speaker to us. And today we are blessed with the presence of Justice V. Ramkumar sir and Justice K. Ramakrishnan sir, of which Justice K. Ramakrishnan sir will introduce the topic for us. Over to you, sir.
Thank you. Good afternoon, everyone.
Good afternoon.
I don't know how Shyam has selected me for introducing a subject which is foreign to me normally, because I am not a tax practitioner, and I never dealt with taxation law also, but except for a few months, immediately on my elevation to High Court, I was with Justice Joseph, who was dealing with the taxation matters. That is only my acquaintance with the tax subject in the High Court, also as a judge also. Anyhow, we are getting a, thank you very much for giving me this privilege to introduce the subject. Anyhow, Karthik Sundaram, expert on this subject, will be giving you all the necessary inputs as to what is taxation, how the constitution deals with the taxation, etc. So I am not being an informal session of empowerment on legal issues. I am not venturing into explaining each and every aspect of it. I just give that part 9 of the Constitution relates with the relations between union and states, and part 12, which is our subject now, and under chapter 1, our finance, dealing with section 2, article 264 to 289, deals with taxation, various aspects of taxation, etc. How this will not be done, etc. There are 3 lists into the 7th schedule dealing with the union, power of the union in dealing with certain matters, power of the state, and concurrent list where both will have their jurisdiction to enact laws. And also, if you go by the legislative powers under section 246A, there is a special provision provided on the Parliament the power to enact laws in respect of goods and service tax. Though originally it was with the in the state list where state governments were enacting the laws on the subject. Anyhow, according to me, everyone was afraid of tax department because they do not know how it will be assessed. What are all the area where you can escape tax? We can only say the escape, not avoiding tax, not evading tax. So it is a complicated subject, but the person who are dealing with the tax and also is interested in the tax, will they say it is an interesting subject, very easy to understand once you have the framework, how understood the framework. We are today getting a good speaker on the subject without going into the subject much, because I am not competent to speak about on those things. The speaker will do the best for enabling us to understand the constitution and the taxation procedure and how the tax laws are being enacted for the purpose of generating revenue, because without tax you can't have income. So generating income, and what are all the areas where the central government can intrude, we can say they intrude into the powers of the state and get the collection of tax and distribution of tax in them. So all these aspects are part of this subject. So with these few words, I invite Karthik Sundaram, an advocate from Madras Tax Bar, who is an expert on this, and during the interaction I came to understand that he has also authored a book on taxation on the subject tax legislative powers under the Constitution. Over to you, Karthik.
Thank you, Ramakrishnan sir, and Karthik, we are all ears to hear what is the difference between tax evasion and tax management to learn a little about that as well. Thank you.
Thank you so much, Justice Ramakrishnan, for the kind introduction. Honorable Justice Ramkumar, my fellow advocates and friends. What I thought is I will deal with the aspect of taxing powers under the Constitution. And as Justice Ramakrishnan also remarked, deal with Article 246A, because today GST is the in subject. I've made a small presentation which I will share, and I will proceed as per the presentation. I hope I'm audible.
Yes.
Yes.
Yes, very much.
Therefore, when we talk about tax per se, we will have to look at the Constitution, because the power to tax emanates from the Constitution. When we look at the Constitution, the most important articles are Article 245 to 248, which give you the legislative power to levy tax. When we look at Article 245, it clearly says extent of laws made by Parliament and by the legislatures of the state. So the Parliament has the power to make laws for the entirety of India, and the legislatures of the state have the power to make laws for whole or any part of the state per se. So that is the basic of 245. 246 is what we refer to as the three lists, which Justice Ramakrishnan had also mentioned. Parliament has the power to make laws in matters enumerated in the union list. The state has the power to make laws in matters enumerated in the state list. And when we come to the concurrent list per se, both the center as well as the state have the power to make laws. Therefore, this is what 245 and 246 prescribe. 246A is the power to levy GST. It was introduced by the 101st Constitutional Amendment Act. For the first time, there is a simultaneous power to levy GST, both on the center and the state. If you look at the law as it stood till the 101st Constitutional Amendment Act, either the state could levy tax or either the center could levy tax. In taxation parlance, this was referred to as the mutual exclusivity of taxing entries. The center could not levy tax on a state subject, and the state could not levy tax on a central subject. Therefore, for instance, on income, only the center levies income tax. On sale of goods, only the state had the power to levy VAT. And on interstate sales, you had a central sales tax. Now, this has changed after the imposition of GST, because for the first time, there is a simultaneous power to tax on both the center and the state. And in constitutional parlance, this is an example of what we refer to as cooperative federalism. When you look at GST, GST is defined under Article 366(12)(a) to mean goods and services tax. Means any tax on the supply of goods or services or both, except taxes on the supply of alcoholic liquor for human consumption. And under Article 248, you have the residuary power of taxation, which means if it is not in list 1 or the state list, the center has the power to tax the same. So when we look at Article 245, two open issues to my mind, which I thought I will share with the audience also, is when you say that the Parliament has the power to make laws for the entirety of India, and the state legislature has the power to make laws for whole or part of any state, who can tax activities which take place on territorial waters? This question gains significance when you look at a coastal state like Kerala or Tamil Nadu, because a lot of activities happen on the territorial waters. Now, the GST Council in one of its meetings said that the territorial waters shall form part of the territory of India unless the Supreme Court holds otherwise in an ongoing litigation. The litigation was in the case of Great Eastern Shipping. One of the questions which arose is whether the states had the power to levy sales tax on activities in the territorial waters. The Supreme Court unfortunately did not decide this question and left the question open, saying that on the other question saying whether or not there's a transfer of right to use, they had already decided the issue and the power of tax also emanated therefrom. Therefore, as on date, this is an open issue. In my personal opinion, it should be the parliament or the center which has the power to levy sales tax or VAT or GST on these activities. Because if you look at Article 297 of the Constitution, it says all resources in the territorial waters shall vest with the Union and be held for the purposes of the Union. So it's very clear that the resources will vest with the Union. It only doesn't include the word saying that the territorial waters should also vest with the Union. But a resource which forms a part of the territorial waters cannot vest with the Union if the waters themselves don't vest with the Union. Even if you look at international jurisprudence is that the ownership and sovereignty over territorial waters rests only with the sovereign nation and not the individual constituent states. Therefore, even as per international jurisprudence, only the Union should have the power to levy tax on activities in the territorial waters. The second part of Article 245, which is of some interest, is that it says that no law made by Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. It's important to note that this is in the context of laws made by Parliament and not laws made by the state legislature. When we look at this aspect per se, two important decisions are the decision in Bengal Immunity Company and the decision in GVK. Bengal Immunity Company was a 1955 decision. The Honorable Lordship had mentioned that the early decisions of the Supreme Court were something really good and something to read about. This is one such decision. What the court had held that look at extraterritorial operation. Normally it refers to two things. One, you make for laws with something inside the state, but they have operation outside the state. Even though you call it extraterritorial, it is strictly speaking only intraterritorial. The second part is laws in respect of nationals of the state. When we are referring to the state here, we are referring to the entire of India. In international law or public jurisprudence, state is synonymous with the nation. And they said that if you make laws for the nationals of India, and even if they do acts outside India, the laws will be applicable to them. And extraterritorial, as appearing in Article 245 subclause 2, must be understood in such a strict sense. Now, when we come to the decision in GVK, which was a decision in 2011, in fact, it was a reference from a previous Supreme Court decision in Electronic Corporation India Limited. Something significant to note is when they came to the Supreme Court on reference, they in fact said that we are not challenging the constitutional validity of Section 9, Clause 7 of the income tax anymore, and the reference is not required at all. However, what the court said is this is a very significant issue, and we deem it proper that the reference be decided. Therefore, the court, despite the parties not wanting the reference to be decided, went ahead to decide what does extraterritorial operation mean. And 3-4 principles which they held are that one, the Indian Parliament does not have the power to legislate for a territory outside India. Therefore, India cannot legislate for the US or the China. This is too basic a principle. Parliament is empowered to make laws with respect to aspect or causes that occur, arise or exist, or which have an impact with the territory of India, or with respect to extraterritorial aspects or causes that have an impact or nexus with India. If it doesn't have an impact or nexus with India, you cannot make any law. Therefore, to simply put it, Parliament has the power to make laws for the territory of India, interest or welfare or well-being or security of inhabitants of India, and even if it has an extraterritorial operation, as long as it has a nexus either with the territory of India or the nationals of India, such law will be valid. So what they have imposed is now what you refer to as a connection or territorial nexus test. And what they have held is that the sufficiency or the connection should be real and not illusory. Therefore, if you look at 1955, what the Supreme Court in Bengal Immunity had said is when we refer to extraterritorial law, it refers to only laws pertaining to Indian nationals, but pertaining to their acts outside India. If you refer to GVK, now it can have a relation to the acts of nationals of India done outside India, or even other things done outside India, as long as there's a significant territorial nexus or a substantial connection between that act and the territory of India. What is now significant is that GVK did not even refer to the earlier judgment in Bengal Immunity Company. In fact, Bengal Immunity Company is a very well analyzed decision where they looked at the Government of India Act 1935, prior legislation, and then came to a conclusion. Therefore, what you have today is you have two Supreme Court decisions on the same issue. One doesn't refer to the other, and both come to varying conclusions. Why I'm emphasizing on this is you will have a lot of issues, especially when Parliament legislates in the context of income tax, to say whether Parliament has the power at all to make such a legislation. And it is in that context that we should look at 245 subclause 2. 245 subclause 1, like I said, has an important role to play when you tax activities in territorial waters. Tomorrow, let us say someone imposes a tax on the activity of fishing. You have this activity of mining and drilling in the territorial waters. So all these are very significant issues which will arise, and the law as regards this is still unsettled in my opinion, and this will require some settling by the Honorable Supreme. Now, we saw that the power to levy tax comes from Article 245 to Article 248. There are also some restrictions on the power to impose tax per se. Some restrictions are that only the Parliament can tax interstate sales or levy GST in the course of interstate trade or commerce. Those are built in 246A, 269A, 269A5, as well as 286. Certain other restrictions are that on the property of the union, the state cannot impose a tax. And vice versa, on the property of the state, the union cannot impose a tax. Now, courts have held that this refers only to direct taxes like income tax and not to indirect taxes. Therefore, on the property of union, you could still levy a VAT. When they refer to the property of the union or the property of the state, they don't refer to state-owned companies or companies owned by the union, but properties which are held by the state as state and union as a union per se. Therefore, Article 285 and 289 are analogous, and there's an exemption from property owned by the union and property owned by the state from taxation. Then if you look at certain other restrictions on taxation, you have a levy of tax on profession, which is a professional tax, and you pay 2,500 rupees per month. I initially always wondered why the cap was rupees 2,500. And if you go to Article 276 subclause 2 of the Constitution, it says that even though the states have the power to levy profession tax, it shall be capped at an amount of 2,500. On the consumption of electricity or the sale of electricity by the union, the states do not have the power to levy tax. Likewise, the states don't have the power to levy tax on water or electricity stored. Therefore, if you look at the constitutional, it's a very interesting document. One, you have your legislative powers. Then you have restrictions on the power to impose tax. Then you have the legislative fields, which demarcate how the power should be exercised per se, which is the next topic which I will dwell upon. Now, a lot of people, when they refer to the lists under the 7th schedule, say that my power or the legislative power is derived from Schedule 7. Strictly speaking, that is incorrect. My legislative power comes from Article 245 to Article 248 of the Constitution. And what Schedule 7 does is it demarcates the legislative fields. These are actually fields of legislation. Therefore, if you look at the Supreme Court decision in Mar Aprem Puri, what it says is that while the legislative power per se is derived from Article 245 of the Constitution, the entries in the 7th schedule only demarcate the legislative fields of the respective legislatures. Look at the decision in Hoist Pharmaceuticals. What it says is the framers of the Constitution have defined the legislative fields pertaining to general entries and the legislative fields pertaining to taxation separately. Therefore, if you actually read through list 1 and list 2, what you will find is initially you have general legislative entries, you have regulative entries, and then you have the powers of taxation, which are specifically demarcated from the general legislative fields per se. What I have done is I've made a table of the various legislative fields of taxation and also laid down certain important decisions. I won't go through everything, but I will just touch upon a few decisions. What is important to note is all these decisions came before Article 246A. And now when you look at any of the decisions rendered prior to Article 246A, we will need to keep in mind the amendment made by Article 246A because it's a significant amendment to the Constitution. There was a question just before we were to start the session saying whether I should declare my agricultural income in my income tax return. Even though there's a column to declare it and there's a need to declare it, if you see legislatively, there's no need because the legislative field of the union is only taxes on income other than agricultural income. Therefore, the union does not even have the power to tax agricultural income per se. That comes under the state list, as we will see. Now, going across, if you see entry 84 is the power to levy excise duty. Now, one significant aspect which I just wanted to touch upon is when we refer to taxation, we refer to direct taxes and indirect taxes. You say, oh, income tax is a direct tax. Excise, VAT, and GST are indirect taxes. He's a direct tax practitioner. He's an indirect tax practitioner. Constitutionally speaking, there is no distinction under the Indian Constitution between direct taxes and indirect taxes. Two decisions have held that. The decision showed by Jeetbhai Patel and a recent decision of Justice Nariman in Bengal Shrachi Housing Society. The distinction is only one of economic theory. Therefore, the distinction is not in law, but it is an economic theory. A direct tax is something you will have to bear yourself, and indirect tax is something which you can pass on to the customer. Therefore, the burden of the levy is passed on to the customer first. Then if you look at entry 91, entry 91 says the rate of stamp duty in respect of the following instruments. Therefore, if you look at the Stamp Act, all taxing powers are either in list 1 or list 2, except for stamp duty per se, which is in the concurrent list. Therefore, the legislative field to levy stamp duty is the only taxing power which is there in the concurrent list. There is no other taxing power in the concurrent list. Therefore, one, the legislative field is in the concurrent list, and the rate of duty is prescribed under entry 91. And the rate of duty in respect of the following instruments alone come under the union list. The rate of duty for other instruments come under the state list. Therefore, if you look at the Stamp Act per se, you have an Indian Stamp Act, then you have a state-wise Stamp Act. So this is why you have two Stamp Acts. One, because it's an article in the concurrent list, the right to prescribe the rate for certain items vests with the union, whereas the right to prescribe the rate for certain other items vests with the state. Therefore, if you look at the Stamp Act per se, and if you keep this legislative background in mind, it will be much easier to understand as to why certain items are with the union and why certain items are with the state per se. Then you have entry 92, 92A and 92B. The only reason I wanted to touch upon 92B is that when they were making sales, the states have a power to levy sales tax on sales or on sales. Now, there was some evasion and they also wanted to levy tax on stock transfers per se. So, what the Law Commission recommended at that point in time was that it would be good to define sale to include stock transfer. Sale until then was nomen juris. It was understood in the manner as defined under the Sale of Goods Act. Therefore, if you look at the Supreme Court decision in Gannon Dunkerley, they say that even though sale per se is not defined, we will understand sale in the meaning as given under the Sale of Goods Act. Thereafter, you had a constitutional amendment in the form of Article 366(29)(a), which is what we refer to as deemed sale. And what the Parliament did, instead of further amending the definition of sale, they introduced a new entry to say tax on the consignment of goods, whether the consignment is the person making it or to any other person, where such consignment takes place in the course of interstate trade or commerce. Therefore, this legislative field gives the Parliament the power to levy tax on stock transfers. And for people who are familiar with the CST Act, if you look at Section 6A of the CST Act, stock transfers were exempt from tax if you produced Form F. If you did not produce Form F, you are liable to pay a CST. And at present, under the GST Act, you are liable to pay an IGST even on stock transfers first. If you look at entry 92C, this was an interesting entry because this is probably one of the few taxing entries which was introduced but never notified. And the power to levy service tax was traced to entry 97 of list 1, which was the residuary entry. They wanted to have a specific entry for taxation of services, which is why they introduced entry 92C. It was introduced on 15/1/2004 and was to come into effect from a date to be notified, but that was never notified, and this is removed by the 101st Constitutional Amendment Act. Therefore, a very interesting constitutional question which arises is, what is the legislative impact of an entry which is introduced but which is never notified? Now, that has not been decided and probably will never be decided because the entry now is no longer there in the Constitution per se. Entry 97 is what we refer to as the residuary entry. If any item is not enumerated in list 2, which is the state list, or list 3, which is the concurrent list, then the center per se will have the power to tax it. Therefore, to tax an item under entry 97, what you will need to establish is that the item is not there as a part of the state list or as a part of the concurrent list per se. Therefore, the residuary power to tax under Article 248, read with entry 97 of list 1, west to the center. Therefore, if we take the levy of service tax per se, the states did not have the power to levy service tax. There was no power to levy service tax under the concurrent list. And even though there was no specific entry to levy service tax, the power to levy the same was traced back to entry 97 of list 1. Now we come to the state list. The first is taxes on agricultural income. Therefore, if you look at the Constitution, why I was saying it's such a wonderful document is if you looked at entry 82, it said tax on income other than agricultural income. And entry 46 says tax on agricultural income per se. Then entry 49 has been an entry which has been the subject matter of much litigation. It's taxes on land and building. Therefore, what do you do when you rent land per se? There's a levy of service tax on the rental of land. That has been challenged on the basis saying that that is nothing but a tax on land and buildings, and only the state has the power to levy it. What the center says is it's not a power on tax on the land and building per se, but it is on an activity related to land, which is distinct from the tax on land and buildings. And the value is derived from the value of land and building, but it's a distinct activity per se. Many high court have ruled against the assessee in this matter, and it's currently pending before the Supreme Court. One other issue arises as to the right to tax mining rights, whether the royalty paid in the context of mining rights is a tax per se or something else, whether it's a tax on land and buildings. This matter has been referred to a 9-judge bench of the Supreme Court in Mineral Area Development Authority, and the matter is pending reference per se. When this matter gets decided, various other issues, such as the true purport of taxes on land and building. What is the true purport of that? What is the true purport of taxation on mineral rights under entry 50? What is the interface between entry 50 of list 2 and entry 54 of list 1, which talks about regulation of mineral rights, will get decided. Because if you look at entry 50, this says taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. Therefore, the question is, when you say limitation imposed by Parliament, does it refer to a limitation imposed by Parliament under entry 54 of list 1? For all those who are advising clients in the mineral industry, it is good to watch out for this reference because it will have a lot of implications. And it will also have a lot of implications when we refer to tax on land and buildings per se. Then, as all of us know, alcohol like liquor is subject to taxation by the state, both a levy of VAT as well as a levy of excise. It's what you refer to as state excise. Alcoholic liquor for human consumption for the present is kept outside GST and is the subject of much revenue for the states. Now, when we look at times like COVID, the first thing we see is all the state governments are increasing either the excise duty or increasing the VAT on alcohol. That's because the play given to the state governments to taper with the rate structure is much more in the context of alcohol than in the context of GST, where the rates are decided both by the center and the state, where it is a mix of cooperative federalism. In the context of a product like alcohol, it is within the exclusive domain of the state, and the state can immediately take a decision without bothering about what the other states say and what the center has to say per se. Entry 53 is the tax on consumption or sale of electricity. Therefore, if you look at it, protection of electricity is different from consumption or sale of electricity. That's what the Supreme Court said in the case of J.R.G. Rao cotton mills. And these are the other entries. Entry 60 is tax on professions. This is what I referred to in the initial part of my presentation, where I said that though it's within the legislative field of the state, it is subject to the cap on the quantum under Article 276, Subclause 2 of the Constitution. Concurrent list, the only taxing power under the concurrent list is entry 44, which is stamp duty per se. If you see the rate of stamp duty on prescribed instruments vests with the union, the rate of stamp duty in respect of documents other than those prescribed vests with the state legislature in terms of entry 63. After that, you have fees, and these are the various fees per se. Therefore, when we look at the constitutional scheme, we have so far seen what are the legislative powers under the Constitution. We have seen what are the legislative fields. Then we go to something which both lawyers as well as judges are very well versed with. What are the principles of interpretation which we apply per se? Therefore, when we look at the legislative fields under Schedule 7, the important principles of constitutional interpretation which you adopt are: one, the rule of widest possible interpretation. You should give the widest possible interpretation to any entry in the three lists. You should give the ordinary meaning. The cardinal rule of interpretation is that the words must be read that ordinary, natural, and grammatical meaning. For all the writ lawyers, whenever you file a constitutional challenge, the first thing which the court asks is, what is the pith and substance? Therefore, when you are challenging a legislation on the basis of legislative incompetence, what the court will see is whether in pith and substance the legislation falls within one of the legislative fields. If in pith and substance it falls within the legislative fields, even if there is something ancillary or incidental encroachment upon some other legislative field. Let us say it falls within the legislative field of the union, but there is only an incidental encroachment upon the legislative field of the state. The legislation will still be valid on the basis of the doctrine of pith and substance per se. Now, the nomenclature is not very relevant. You will have to look at the pith and substance. When you look at Article 246A, which prescribes a list, it starts with the words with respect to any of the matters enumerated in any of the lists. So when you look at with respect to, it doesn't say in relation to, or it doesn't say in respect of the specific matters. It uses the terminology with respect to. With respect to is a term of wider latitude, and the pith and substance test in effect flows from these words with respect. What the Supreme Court has held is that the bottom line is to look at the legislation as a whole. And if it has a substantial connection with the entry, the matter may be taken to legislation on the topic per se. The other doctrine we'll have to look at is the doctrine of colorable legislation. So this is a doctrine which we look at when we talk about legislative incompetence. It comes from the principle saying what cannot be done directly cannot be done indirectly. Therefore, if a legislation is on the face of it, it looks like it will fall within the legislative field, but in pith and substance it falls within some other legislative field, then the doctrine of colorable legislation will be attracted. You shouldn't only look at the form of the legislation, but should look at the substance of the legislation as well as the effect of the legislation per se. If in pith and substance the legislation falls within a particular legislative field, if the encroachment is only incidental, then there is no colorable legislation per se. Even though it is called colorable legislation, you look at only the question of legislative competence. You cannot go into the question of motive of the legislator per se. And the legislation, if there is an incidental encroachment or only a minor part of it falls within some other legislative field, the doctrine of reading down should then be adopted and the legislation can be read down. Number 4, the aspect theory of legislation. This is an exception to the doctrine of pith and substance. Different aspects of the same transaction can be subject to different taxes as long as there is no overlapping in law. There can be an overlapping in fact, but there cannot be an overlapping in law. To give you an example, both excise duty as well as VAT were being levied on the same goods, but on different transactions and on the same value. When you sold the goods, on your transaction value, there was levied an excise duty. On the sale price, there was levied a VAT. The excise duty was levied by the union government and the VAT was levied by the state government. A question which arose is, aren't you subjecting the same value to two taxes? What the court held is, in fact, it may be an overlap, but in law, there is no overlap. Excise duty is a levy on manufacture. Only the valuation is the value of the first sale. A sales tax is a levy on the activity of sale, and the transaction value is the value of the first sale. Therefore, there may be an overlapping in fact, but there is no overlapping in law per se. The Supreme Court, in the decision in All India Federation of Tax Practitioners, had a chance to look at this, where they said, on the profession, you levy a profession tax, and on the exercise of that profession, you also levy a service tax. This is in the context of chartered accountants, where there was a service tax on chartered accountant services. What the court held is the tax on the profession is different from a tax on the exercise of that profession. There is no overlapping in law per se, and on an application of the aspect theory, you can have both a tax on the profession as well as a service tax. Next, we come to the ragbag theory of legislation. What this essentially says is that you don't need to trace the taxing power to one specific legislative field. You can trace the taxing power to multiple legislative fields. The best examples of these are the Annual Finance Acts. If anyone looks at the Annual Finance Act released by the Center, you will see the law relating to previously excise duty, customs duty, service tax. Excise duty was traced to entry 84 of list 1. Customs duty was entry 80 of list 1. Service tax was entry 97 of list 1. Therefore, you can have an enactment where you trace the legislative fields to various entries in a given list, and it did not draw sustenance from one single entry alone. Because you can take the help of various entries, it is referred to as the ragbag theory of legislation. When you challenge the legislative competence of a legislation per se, the legislature, while passing the legislation, did not have in mind the legislative power. It can draw sustenance from various legislative entries, and this is what you refer to as the ragbag theory of legislation. Therefore, in short, whenever one challenges the constitutionality of any legislation, especially a tax legislation, what we need to keep in mind is the fact that there is always a presumption of constitutionality in favor of the legislation. What the court should look into is the pith and substance theory. If there's only an incidental encroachment, then the legislation is valid. The court cannot go into the motive of the legislation. What they can look into is only the legislative competence. Apart from passing the test of legislative competence, the act can neither be in violation of provision of the Constitution, nor can it operate extraterritorially. These are additional tests. Therefore, whenever one files a writ petition, normally the challenges can be put into two baskets. One is the test of legislative competence, which is what I've dealt with. And the second test is violation of fundamental rights or violation of constitutional rights and other constitutional provisions. Now that we have seen Article 245, the power to levy tax, the legislative fields, and the doctrine of interpretation, let us come to Article 246A. Till Article 246A, it was very common for the courts to hold that there was mutual exclusivity of taxing powers. What this meant was that the legislative fields of the union as well as the state were very specifically demarcated. If you saw the demarcation, on an intrastate sale, only the state could levy tax. On an interstate sale, only the center could levy a tax. On liquor products, only the state could levy tax. On all other products, only the center could levy an excise duty. For the first time, by the constitutional amendment, there's been a simultaneous power conferred on both the center as well as the state to levy a tax, which is now called the GST. This is under Article 246A. However, one distinction is that any transaction in the course of interstate trade or commerce, the power to levy tax vests only with the Parliament. Now, this is a non-obstante clause, which means it starts off by saying notwithstanding anything contained in Article 245 and 246, which will override 246 and 254 of the Constitution. I'm sorry, it was 246 and 254. For the first time, a simultaneous or concurrent power has been granted for both the union and the state to make laws in respect of GST. One significant decision, which I thought I will draw your attention to, is the decision in Reliance Industry versus State of Gujarat. Before I go into the decision, I will give some context to what happened. The 101st Constitutional Amendment happened in 2016, and it had a transition clause say that even though the amendment has happened, the provisions of the Constitution as it existed prior to the amendment will continue for a further period of 1 year or till the state and the union make laws in exercise of the power conferred under Article 246A. Therefore, what has happened is after the amendment or the 101st constitutional amendment with effect from 16/9/2016, the question which arose is whether what was saved is only the provisions of the state VAT laws of the Central Excise Act as they existed on 16/9/2016, or do they have the power to make legislation till 1/7/2017, which was the date of introduction of GST. If you look at GST, there are transitional provisions under various state GST acts as well as the union GST acts. What they say is that we will still continue to have the power to issue show cause notices in respect of VAT. Let's take, for instance, section 174 of the Kerala GST Act. The Kerala GST Act says that we will have the power to issue show cause notices in respect of things which happened under the Kerala VAT Act. One important and significant question which arises is that the legislative field, which had to be read along with the legislative power, no longer exists at all. Entry 54 of list 2 no longer exists. Therefore, do you even have the power to make such a transitional provision? If you did not have the power to make such a transitional provision, then after 1/7/2017, can you issue a show cause notice for recovery of arrears under the Kerala VAT Act pre 1/7/2017 because you no longer have the power to levy VAT? This question is the subject matter of discussion before various decisions in the Kerala High Court itself. Two significant decisions are Sheen Gold Jewels and Baiju, and I believe the matters are before the appellate court in Kerala. I think in that context, one of the most important decisions is the decision of the Gujarat High Court in Reliance Industries versus State of Gujarat, where there was an amendment to the State VAT Act after 1/7/2017. They made an amendment in the limitation period or the limitation period for which notices could be issued. What the state argued is even after my legislative field under entry 54 and my power to levy sales tax was taken away, I still have the power to levy sales tax under Article 246A, which gives me the power to levy GST because it's nothing but tax on goods and services. What the court held is that Article 246A is a new entry. It's an integrated entry or an entry which grants a simultaneous or concurrent power for the union and the states to levy GST. The way the GST mechanism operates is that the entire model law as well as the levy is decided by something called the GST Council. The GST Council is a statutory authority under Article 279A of the Constitution, which comprises of the Union Finance Minister and the state finance ministers of all the states in the Union territories. They come together, they discuss all the laws, they discuss that they will have a common law all across India. Therefore, if you look at the GST law, say of Kerala, of Tamil Nadu, of Gujarat, or the Central GST Act, all the provisions are in pari materia with each other. This is for the purpose of harmonization of taxation. Therefore, in this context, what the Gujarat High Court held is that if you look at the legislative entry per se and the legislative power under Article 246A of the Constitution, what you have is an integrated power to tax. You cannot further break up Article 246A and say, out of Article 246A, I will tax the sale portion alone. I will have power to levy a tax on the excise portion alone. Article 246A cannot be broken up, and it's a simultaneous power which needs to be exercised by the union and the states. Number two, on how you would interpret the Constitution. They said that once the Constitution 101st Amendment Act took away or deleted entry 54, it means they didn't want the power to be given to the states anymore to levy sales tax. You have the power to levy a GST. I take away one power. I give you another power. I cannot read the constitution in a manner that you can retain the power which is taken away. Therefore, they said you need a harmonious interpretation of the constitution, and you cannot have the power to levy sales tax per se after it was taken away under entry 84, under entry 54, and entry 54 of list 2 was deleted per se. The third thing they held is that you have a GST compensation act for any loss suffered under sales tax. The union compensates the states. Once there is a compensation act and you enact a compensation saying because you no longer have the power to tax and for any revenue loss, we will compensate you till a prescribed date. Then you cannot, under the guise of Article 246A, try to exercise the same power which has been removed. I can see some entries in the chat box, and the first decision of the Kerala High Court was by Justice Damasheshatri Naidu in Sheen Gold Jewels. I'm informed that the same is pending before the appeal court. I'm also informed that the decision in Baiju, which is by Justice Jayashankaran Nambiar, is also before the writ appeal court in Kerala. And this decision in Reliance Industry is a very significant decision in my opinion, which will have a great bearing on the matters before the Kerala High Court. Now, what I will do is I will just shortly conclude on the various aspects which I discussed. Therefore, to sum up, there is a distinction between general subjects of legislation and tax per se under the 3 lists of the 7th schedule. Till the 101st Constitution Amendment, there was mutual exclusivity of taxing powers that no longer exists after Article 246A. Therefore, whenever one is reading judicial decisions which were rendered prior to the 101st Constitutional Amendment Act, we need to keep in mind what has happened by the 101st Constitutional Amendment Act. Article 246A is possibly the only entry where both the legislative power as well as the legislative field come from Article 246A itself, and you need not refer to either list 1, list 2 or list 3 of the Constitution. Union has the exclusive power to legislate only in respect of interstate trade or commerce, and for anything which is not prescribed under Article 246A or the state list, the exclusive power to take tax will vest with the Parliament in exercise of its powers under Article 248A, read with entry 97 of list 1. Therefore, whenever there is a challenge to any enactment in defending the validity of law on the question of legislative competence, all that the state needs to show is that the law is supportable by any entry within the competence of the legislature. It can take the help from any number of entries in that particular list, and this is what we refer to as the rag-bag theory of legislation. I thought I'd just give a short overview of the constitutional provisions and the law related to taxation. Thank you so much for patiently hearing me, and I'll be happy to take any questions on the subject. Thank you so much.
Thank you, Karthik. Tax, as we all know, is not something that can be easily digested. I mean, that's at least what a layman, or to a certain extent what the lawman also think. So I'll do one thing. I'll get the comments of Justice K. Ramakrishnan sir and Justice B. Ramkumar sir before we go to the interactive session. Ramakrishnan sir.
That'll be most.
Really, Karthik, you have done a great job in consolidating the legislative function with the constitution on tax. In a nutshell, we can say, though there are controversies regarding the power and how to collect, who to collect, or who to impose, etc. Anyway, it's because as Shyampadman has said, even today I do not know how to calculate my income tax. I will normally send all my papers to my auditor.
Sir, I can make it easy. You can just send across LinkedIn to me.
Because even my wife used to say, why you are sending it? There is a form, you can fill it up. Everything is easy nowadays. Online, you can do everything. I said, no, I don't want to take a risk. I will give it to my auditor. He will do it for me so that I will be safe. because I can blame somebody else for not doing something. If anything goes wrong, he will take care of me. So in that way, the tax is always a complicated subject to understand, according to me. I mean, they could have made it so simple also sometimes, but that is not being done. And there are overlapping areas where taxes are being also imposed. How to resolve all those things is one area where people are not able to resolve. That is always there, because that is the reason why a number of case laws are coming for the purpose of even one entry to another entry. Because one entry, some article is taxed in a lesser price, lesser rate. The same thing which come for another entry, you will have a larger tax will have to be paid also. I do not know what is the things based on which these things are done. But I had on occasion to consider one case on this bone meal case or something like that. Where I somehow, with the help of Justice Joseph sir, who is now in the Supreme Court now, able to resolve an issue, and then judgment was rendered by me. Because really, it was with his help, it was able to done. Because even now, I could not understand what is the principle behind it. Anyhow, because when we are relying on the decisions for those purposes and coming to a conclusion, and normally, unless it is unconstitutional or arbitrary, normally it goes in favor of revenue. Normally, what is your view on this?
Thank you so much, Justice. In fact, to tell you, even I just send my income tax returns to my auditor. I don't fill up my income. And on what you're saying, I do totally agree with you that except where there are legislative challenges, the tax matters mostly go in favor of the revenue. Also, what happens is that in a lot of matters, once one assessee gets an interim order, there is always a tendency for the other assessees to come and get an interim order so that there is relief from tax for the time being. And then they say, when it comes later, we will see what to do. Therefore, you're very right in saying so. Justice.
And not only that, by the time some amnesty scheme will come, they will get some exemption, they will pay off for one-time tax and they will get rid of it.
Yes, very much.
Because tax matters normally will not be taken up. For final hearing, I never come across during that period where I was, short period where I was there. Interim orders, once you decide it at the interim stage itself, well and good. Otherwise, it will be difficult.
Yes, Justice.
Thank you, sir. Over to you, Ramkumar, sir.
My God, a great relief came to me when no less a person than an expert like Karthik said, he is also relying on his auditor for his tax returns. For a taxation challenger mind like that of mine, the dark area in the brain will turn into gray area. That's all. That alone has happened to me also. Let me confess. See, this excellent lecture confirms the fact that unless you practice a particular branch of law, whatever theoretical elucidation you receive or you are exposed to will not take you far. So I let the tax practitioners flourish. I will continue to be a confirmed criminal.
Sir,
Thank you. Wonderful.
Thank you so
Excellent.
much, Justice.
Excellent.
Thank you so much.
Karthik sir, just a stray thought, might be a stupid thought as well. Instead of having this different points of taxation, why can't we just have an expenditure tax? Whenever you take the money out to spend, you will be taxed. So that whatever way you procure, whatever way, end of the day, you have to spend it. So expenditure tax can be imposed, or rather could be implemented.
See, very much. One thing is, all transactions are not digital transactions or done through the banking channel. Therefore, you really don't have an account of transactions if you had to impose an expenditure tax. But if you see Dr. Subramaniam Swamy, who apart from being a politician is also a leading economist, he's always been of the view that India should abolish income tax and have a tax on banking transactions. Therefore, your views are quite in line with that. And I think that is something eminently doable as long as we have all transactions which are recorded in formal manner or recorded by way of digital transactions or banking transactions. as we increasingly move towards digital transactions, this is something we can definitely.
Thank you. The person who introduced us to you and you to this platform, Mohan Kumar sir. Please unmute yourself.
Hi, Karthik.
Hello, sir. Thank you so much for
Hi,
introducing
Karthik.
this platform, sir.
You have introduced the right person.
To the right audience. On taxation challenged.
Though we had a short acquaintance, but still I found that he is the right person. Hello.
Yes, sir. Please.
You are on the treadmill or something?
No. I am. I feel myself confused as to whether I am audible or not.
You're audible, but visibility, I think you are having an earthquake there.
Okay.
You are moving from.
Okay. Karthik, you rightly point out Baiju's case because it's a matter of general importance as far as the lawyers of the High Court of Kerala are concerned. 2020, 1 KLT 233 is the citation. I may repeat. 2021 KLT 233. Baiju versus sales tax officer. And in that case, the question was the section 25, subsection 1 of the old act, the VAT Act. Under that, show cause notice was issued, and it was beyond the period of limitation prescribed under the statute. So, whether proceedings can be initiated by issue of show cause notice. That was already decided by a division bench of this court in 2018, 4 KC 666. Then, in spite of that, the authorities proceeded with the show cause notice, and even assessments were made. And then this matter came up. In this matter, it was made very clear that the taxing statute is having no retrospective effect at all. I mean, an amendment to the taxing statute cannot have any retrospective effect at all. And that is illegal to proceed under section 25(1) because the very bold point that in the judgment, Justice Jessica Zambiar has made clear, on expiry of the period of limitation, then the assignee gets a right of immunity from assessments. That's a point raised. So, though it is not referred to, I may also point out that Article 265 bar will also come in, right?
Yes, sir.
Because no tax can be levied without authority of law. Because Article 265 is a bar for levying tax without authority. So, that aspect will also come in. Anyway, as you said, it has been referred to the division bench and it may go to full bench also. Now, another point is that is my doubts. See, building construction workers cess that is levied under the Central Act. Section 3 lays down the procedure for levying tax that is based on the cost of construction, that is ad valorem. The Kerala government has issued a notification in 2018 fixing slab rates, that is prefixed rates. So my question is that when a central statute is there, can the states, whether under the power conferable under the subordinate legislation, that is for rule making power, this is only a notification, whether the state government can fix a different method of levying cess, because the difference is that under the Central Act, cess can be reckoned with reference to the cost of construction, so that may vary. That's ad valorem. But the government notification, state government notification is that slab rates are fixed. If it is worked out, in some cases it may come to double the amount payable under the actual rate, ad valorem rate. So is it not illegal? Because the inconsistency in Article 251 and 254, that is repugnancy, would it not arise? 251 and 254, because there will be repugnancy between the central statute and the law made by the states, because rulemaking, whether under rulemaking power or under subordinate legislation or under any pretext, if any method is devised for levying tax, is it not hit by Article 251 and 254?
So shall I answer query now, sir?
Yes.
Yeah.
First of all, thank you once again so much for introducing me to the audience. It's been so nice of you. On the second part of it, we'll first need to trace the power to levy this building cess. I will once again have to look at it, but from what I remember, there was a Supreme Court decision in Diwan Chand Builders where they traced the history of this Building Cess Act. Therefore, normally what happens is if it's in the concurrent list, both this union as well as the state will have the power to levy it. And if the state levies it only as per the state and the union legislation does not levy it for the state, there is no question of repugnancy. But if both operate simultaneously, that's when you come to the question of repugnancy. The second thing, as you have rightly pointed out, if it's one legislation and the state is giving effect to the central legislation, then the well-established principle is that the delegated legislation cannot override the parent act. Therefore, if the charging section as well as the rate is prescribed under the parent act, the delegated legislation, which is by way of notification, cannot override the parent act per se. And on Baiju, sir, I totally agree with you. I had also written a small article on the Baiju judgment, and I think we'll have to wait and see what happens before the division bench. And given the importance of the matter, I do think it will go to a full bench of the Honorable Kerala High Court also. And
there is an earlier division bench also. Justice Vinod Chandran has written a judgment, beautiful judgment, 2018, 4KH 666. Yeah,
that I think was just before the levy of GST. That was on the power of revision and reassessment under the Kerala VAT Act.
Exactly. That is it.
And sir, one more thing I think you will be very happy to know. In fact, after that, my great grandfather, in fact, had a practice in Calicut. So he used to be a lawyer in Calicut. So I just thought I'll share with you. So my connection goes back to Calicut also, even though we don't have any immediate family in Kerala right now.
His name, please?
Iyer.
Pardon?
Vakil Ganapati Iyer.
Oh,
I just thought I'll let you.
Very good. At least Calicut connections. Good. We have Radhakrishna Murthy with the hands up. Please, can you unmute yourself and put the question?
Yeah, can you hear me?
Yeah.
Yeah, actually, by virtue of now Article 246A, whether the state has power to levy tax or not?
So the state definitely has the power to levy tax, but what they can levy now is only a GST. They can't levy a VAT or a state sales tax. They have the power to levy GST under Article 246A. And to understand what is the meaning of GST, you will have to look at Article 366, subclause 28 of the Constitution.
Because there are many taxes that they have included and all, because of GST, state, I mean, in certain goods and all, where that they cannot impose sales tax and other taxes, no?
So all your goods, the state can levy a GST. It's now only on certain goods do they impose a VAT or a sales tax like alcohol and everything. Everything else they impose a GST.
Okay. So they have power, it means.
They do have the power.
Oh, thank you.
Thank you, Radhakrishna Murthy. I think there are no further questions put in the chat box. So over to you, Prem.
Well, Karthik, it was an insightful talk. And in continuation of what Mohan asked you, let me ask you a constitutional aspect regarding the tax law, though I'm not much into this field. Now, as far as I have read, is some judgments I have read, some judgments. So, in my opinion, the Indian judiciary, it has failed to distinguish tax as public law, first of all, because this is one which deals with the duties and relationship of individuals to the government as well as the society. And you can see the snowballing prominence of the, on what you call the SSC as the focal point for the taxation laws, both either by the judiciary or by the legislature as the case may be. Now just see, we had a 1962 ruling wherein a 7-judge bench of our Supreme Court, that's an automobile transport Rajasthan Limited's case, were overlooking all the principles of taxation. The Supreme Court went on to introduce the concept of compensatory tax, which of course was overruled 55 years later in the Jindal Stainless, that's a 9-judge bench, that which would say that there is nothing what we call compensatory about a tax. And it was divergent what you say to the fundamental doctrines of taxation per se. So let me ask you, have you noticed any anomalies in the 9-judges bench decision?
Prem, I think that's a very, very interesting question. And if you ask me, I would think conceptually, the 9-judge bench decision in Jindal is a correct decision. Because what the Supreme Court in 1955 and onwards, the automobile case and the Aitbari case, they came to what is known as a compensatory theory of tax. Now, if we look at tax per se, there is nothing compensatory about it. It is an extraction of money from the individual by the sovereign. If we replace the sovereign with the union or the state, the union or the state extract tax from you, not owe you anything in return. They are supposed to be a welfare state. There is, however, when you look at anything in tax, any of the judicial decisions or economic theory, there is a distinction between a tax and a fee. There is no quid pro quo in tax. If you pay a fee, you get something in return for consideration. You pay something, you get something in return. So in the concept of tax, there is nothing like that where you get something in return. It is supposed to be used for the welfare of the people, but whether or not they use it for the welfare of the people is a question which I don't need to go into right now. Yeah. So a tax is a compulsory extraction from the public. Having said that, once it's a compulsory extraction, then the very concept of having a compensatory theory of taxation does not even arise, because how can you have a compensatory theory when the primary premises it's a compulsory extraction per se? If you look at all the decisions from 1952 to Jindal, they went on to say, okay, we extract tax from you, we will see whether we are laying roads for you. All these are in the context of entry tax. Or we are upkeeping agricultural mandis. Okay, we can't measure one-on-one. Therefore, we will see whether we can measure it on a collective basis. And then finally in Jindal, what they held is there can be no compensatory theory of tax per se, because tax by its very nature is a compulsory extraction. Therefore, one of the things which prompted me to write my book, also titled Tax Constitution and the Supreme Court, was the Jindal decision. And the very fact that for about 60 years in India, we couldn't come to a conclusion as to whether tax could be compensatory or not. Therefore, if you look at my first chapter, in fact, that's what I've written upon. And I think it's a very, very pertinent and correct question. I had the same question running through my mind, and I do believe Jindal is the right law.
But let me ask you, somebody has asked the citation of Jindal. Jindal is 2017-12 SEC, page 1. And Karthik, let me ask you, did you read the full judgment of Jindal? See, I'll tell you one thing. Of the 9 judges, the majority, of course, Justice Ramana was supporting the majority, and Justice D.Y. Chandrachud went against, and he wrote his own minority judgment. Now you can see in Jindal, another question which came up, of course, it was actually needless. Because Justice Ramana initially went on to say that as on that particular date, my memory doesn't fail, it was somewhere during November 2016, the judgment comes. He went on to say that as on that date, 17 judgments of 9 judges or more were there in the Supreme Court, of which he would say that 4 were by 11 judges and 1, Keshavananda Bharati, by 13 judge. So, according to him, there are only 12 9-judge benches. Now, Justice D.Y. Chandrachud, he would say, as on that particular day, it was what was reported were only 8 reported decisions of 9-judge benches, whereas both of them are actually wrong. Actually, there were 13 judgments as on that particular day, and now we have 17. And of course, 6 matters are pending, including the Sabarimala as well as the taxation issue, which you have also raised. Did you read that full judgment of the Jindal? Did you have the occasion to?
I did, in fact, read the full judgment. And what you are raising also gives rise to a sub-question, because what happens in India is we don't have the ratio of the decision written by the judges. So what is the ratio of a decision like this has to be deciphered in a further judgment to say this is the ratio of the decision. Therefore, I think something which is needed, and the honorable justices who are there over here may also opine on that. I think, see, laws are made for the common man. Laws are not made for judges or lawyers. Judgments are also not written for judges or lawyers. This is my personal opinion. It is for the common man. Therefore, to expect common man to read 4 opinions or 5 opinions, some concurring opinions, some dissenting opinions, and decide what is the ratio of the judgment itself is something very difficult. So what the judges should do is, once they write all their opinions, come out with saying that these 5-6 points are the ratio decidendi of the judgment, and the rest of it are not the ratio decidendi of the judgment. Just to add on one more point, I did one more session for the Madras Tax Bar on the basic structure of the Constitution, which is the Keshavananda Bharati judgment. And if you read the judgments of the Supreme Court also, what they say is that there was no ratio decidendi emerging even from Keshavananda Bharati per se. To say that the basic structure framework was only in Justice Khanna's opinion. The others talked about essential features of the Constitution. They didn't talk about the basic structure theory per se. And Justice Khanna said that the basic structure theory per se flows from the word amendment in Article 368. All the other judges said that it flows from the various provisions of the Constitution. Therefore, till now, even though everyone says that the ratio of Keshavananda Bharati is that it holds the basic structure theory, if you read the further judgments, Indira Gandhi versus Rajnarayan, Minerva Mills, Paul I.R. Coelho, none of them really get into what is the ratio decidendi per se. Therefore, what you have raised is a very, very interesting concept. And I think probably you can have one session on what is the ratio decidendi and how will you really interpret such judgments. If the honorable justices could also say a few words on this, it would be my privilege. Thank you.
Now, see, as far as ratio is concerned, there is a 58 judgment of His Lordship Justice Vivian Bose, that is in the Ram Singh's case. Suppose you have 5 judges, or say 3 judges, or 11 judges, as the case may be. What you treat as a benchmark is a minimum that is set by a judge, and then what is built upon that minimum. So the minimum is set as a benchmark, and what you go above that minimum, that is not the ratio. The minimum what is set, and what and on what point the other judges also concur. So that is to be treated as a ratio. And now we see many judgments of fractured majorities, where you can see absolutely no ratio itself would be there. Even the Supreme Court judgments, because somebody else, he would write a separate judgment, he won't say about the other thing earlier. Many number of judgments you have those kinds of shortcomings, but still we presume that it is a ratio and go ahead with those judgments as binding precedents.
No,
Thank you so much.
I would totally agree with you on that.
I think we, like Karthik said, we might require a separate session on that, because who will police the police is the question, or who will say what is the judgment intended, or what exactly is, and it has to be interpreted, like interpretation of statutes. We might require a statute of interpretation of judgments. I don't know. Can you unmute yourself, Nyayapati Vijay?
Yeah, hi. Can you hear me?
Sure.
Yeah. So far as continuation of the topic, there is the judgment of Inamdar in the minority institutions case. There was a 5-judge bench which was actually interpreting a larger bench decision. If you see that the minority in a judgment case with regard to educational institutions' rights, minority educational institutions' rights, there was a 5-judge bench, a constitutional bench interpreting a larger bench decision as to what is the principle actually living. So
you're right.
that is with regard to TMA Pi case.
TMA
Was
Pi.
interpreted,
You're right.
Was interpreted in by a larger bench. Now the doubt I have to the speaker is with regard to Article 289, where there are certain indirect taxes which are being, what is the status of the position with regard to indirect taxes being levied on the state income? See, there are certain, the question which is a little more precise is that state has certain statutory duties. And in exercise of that statutory duties, they do something, they give an assignment or do something. Those assignments are also charged under service. Now, this is a doubt I have with regard to 289, whether such a tax is leviable on the state, because it's primarily a state income. And state is not doing business. State is actually exercising, is doing its statutory function.
So, to answer your question, the way Article 289 reads as property and income of a state shall be exempt from union taxation. Therefore, the way it has been interpreted by the Supreme Court is to say that we are only exempting the property of the state from taxation, even though it uses the word income of a state. It's been interpreted to say that it is only a direct tax which is exempt and not an indirect tax which is exempt. Therefore, in respect of activities undertaken by the state, there is still a levy of indirect taxes. There is a decision, early decision of the Supreme Court in Re Customs Act.
True.
It is an advisory.
The doubt I had is, I was informed that matter is referred to a larger bench in the matter of railways.
Okay.
I wanted to know about that, because if you see Customs, it's a case where levy of custom duty.
Yes.
That is with regard to a equipment imported by the state. And there is also this Delhi case. I think the properties of something to do with properties located in Delhi, whether they are liable for property tax and all.
Tax or not, yes.
Yeah. So I think you are referring to that, where this principle of property and income is kind of distinguished there.
Yes.
But in cases where, see, there is no this precise law, in cases where this state is doing statutory duties. See, as far as Sea Customs is concerned, it's a case where the state has purchased certain equipment, where in its own, for its own construction of building or for its own. Here, it is not constructing any building, it is under compulsion of a statute. To put it more precisely, it is with regard to a mining issue. I was more concerned with regard, because the minor minerals are delegated to the state to execute lease deeds. It's the state which executes. Now, state gets a royalty. Now, that royalty is being service taxed. So, that royalty which they get is in exercise of their statutory duties. It is actually an income which falls under, it is not a venture, unlike the Sea Customs case or the other Delhi case which you are talking about.
I understand what you are saying, sir. The law until now is that 289 only exempts direct taxes, because it says use the word on property or income. So any activity may eventually result in generation of income to you. But what you are taxing is the consideration for the activity. Therefore, the way Article 289 reads at the moment, I would think that the opinion in Re Customs Act is right, saying it refers only to an income tax act. As regards your specific query on taxation of royalties, I think the greater issue is it's been held that royalty itself is a tax in the case of India Cements.
That is a matter of subsequent debate, which you know.
Yes, which is the difference between India Cements and Kesora.
True.
Now that's been referred to a 9-judge bench.
True.
So definitely in all the writ petitions which are being filed on this issue, I have filed 2 of them myself before the Madras High Court. We have taken an argument saying a statutory or a sovereign function cannot be the subject matter of tax. But personally, I don't think that will go very far, that argument. And I think it will hinge quite a bit more on legislative competence. Because if you see, the royalty is imposed under the Mining and Mineral Act, which is under entry 54 of list 1. Whereas if you see what do you actually pay the royalty for is only for the grant of mineral rights. What you get in return is the power to excavate, or after exploration, the excavate minerals per se. Therefore, you can probably take a stand saying only the state government has the power to levy tax under entry 50 of list 2, and the union does not have the power to levy tax under entry 54 of list 1. So the power to levy royalty comes from section 6A of the Mines and Minerals Act. And it's only a delegated power given to the state government to collect the tax per se. The levy, I understand, is not by the state government. It's only a power to collect which is given. Therefore, the act per se, as well as the power to legislate, flows under entry 54. I think probably that may be a better argument, and the argument that is the conflict between India Cement and Kesoram, rather than this. But as an argument, definitely it's something which you should take up.
Sure. Thank you.
Thank you very much. That brings us to the end of the 68th session of Legal Empowerment Through Interaction lecture series. Sir, had we known that tax and tax issues was this engaging, entertaining, we would have put more interest into that. I mean, we were always taught, even in the law college days, like tax. No, we had an option in the final year, either to take tax or labor. And almost 99% of us took labor, because even though the marks score would be less, it would have been easy to master, or rather at least reproduce in the exam papers. Today, it was an eye-opener. It was wonderful. And we were privileged by the presence of Justice B. Ramkumar and Justice K. Ramakrishnan, sir. So, Karthik, sir, thank you very much. And all of you, dear participants, let us meet again tomorrow at 3:30, where we get into another aspect of law, or another facet of law which we have not touched upon till date, that is service law. Tomorrow, Senior Advocate of the High Court of Kerala, Dr. Satishan KP, will be dealing with disciplinary action against government employees. Let us meet again 3:30 tomorrow. Till then, don't overtax yourself. Take care. Stay safe. Thank you very much.
Thank you so much. Thank you.
Thank you.
Thank you, Justice. Thank you.